Hi, welcome to Group 8's presentation of Freedom of Speech and the Press, presented by Ashley Reed,
Brianna Jimenez,
Fernando Quintero.
and Miranda Ramirez.
Here we have a quote from our 26th President of the United States, Theodore Roosevelt. He's quoted saying, "Free speech, exercised both individually and through a free press, is a necessity in any country where people are themselves free."
There are two really important things to remember about the First Amendment protection of free speech. The primary reason to have freedom of speech is to allow for public criticism of the stupid government. Stupid government. That's the sort of thing that can land you in jail in countries that don't have strong free speech protections. Or should I say, you would be Putin jail. Don't put me in jail. Oh, that's right, I'm in the US, it doesn't matter. The stories of oversensitive kings and dictators silencing people who question their rule or even make jokes at their expense are too numerous to recount. But for the most part, that kind of thing doesn't happen in the US, which is why no one gets arrested for carrying around a giant picture of Obama as Hitler or former President Bush as a monkey. Well, that stuff's okay as far as the First Amendment is concerned, but that doesn't mean it's respectful or in good taste. The second thing to remember is that the First Amendment protects you from the government doing things that try to deny your speech, but not anyone else. What this means is that you don't have an absolute right to say whatever you want, wherever you want, to whomever you want, and not suffer any consequences. Is it?
Constitutional provisions. In Madison's version of the speech and press clauses, introduced in the House of Representatives on June 8, 1789, provided, "The people shall not be deprived or abridged of their right to speak, to write, or to publish their sentiments, and the freedom of the press, as one of the great bulwarks of liberty, shall be inviolable." The special committee rewrote the language to some extent, adding other provisions from Madison's draft. And that draft was edited and then eventually became the First Amendment on the Bill of Rights in 1789. There was also the Sedition Act in 1798, and of course the 14th Amendment in 1868. The Sedition Act of 1798. In one of the first tests of freedom of speech, the House passed the Sedition Act, permitting the deportation, fine, or imprisonment of anyone deemed a threat or publishing false, scandalous, or malicious writing against the government of the United States. Of course, this did not go well with the United States citizens, and signed into law by Adams on July 14th. The law proved immensely unpopular with the public, and the president lost re-election to Thomas Jefferson in 1800. Under the incoming Republican administration, the Sedition Act eventually expired on March 3rd, 1801. So, under the umbrella of freedom of speech and the press, what's not protected? In regards to speech, anything that includes obscenity, fraud, sedition, which incites imminent lawless action, fighting words, those could be threats, anything that violates intellectual property law, defamation, and minors. And with press, it includes anything with obscenity, defamation, anything that endangers military or the national security, and sedition.
Supreme Court decisions. There are several notable cases I will highlight in the next few slides that are representative of Supreme Court rulings that have upheld freedom of speech and the press. These include New York Times v. Sullivan, Brandenburg v. Ohio, Tinker v. Des Moines School District, and Texas v. Johnson. New York Times v. Sullivan. This case took place in 1964 during the Civil Rights Movement and centers on freedom of the press and libel. The New York Times published an ad in support of Dr. Martin Luther King Jr. and described allegations of police brutality against protesters by the Montgomery, Alabama Police Department. The advertisement contained several factual errors and inaccuracies. Public Safety Commissioner L.B. Sullivan, offended by the paper's commentary, filed a label lawsuit against the New York Times and won his case in the Alabama courts. The decision was appealed to the Supreme Court, which ruled unanimously in favor of the Times, citing the lack of actual malice on part of the newspaper. In this landmark decision, the court deemed that public officials must prove that the reporting of false information is done with intentional recklessness to be considered libel, and in doing so, upheld the freedom of the press. Brandenburg v. Ohio. In 1969, Ku Klux Klan leader Clarence Brandenburg spoke at a televised rally promoting hateful language and advocating for violence against minority groups. He was subsequently charged with breaking Ohio's Syndicalism Act, which criminalizes the promotion of violence for political reasons. Brandenburg was convicted and appealed the decision, claiming that Ohio had violated his First Amendment rights. The Supreme Court reversed his conviction and ruled that Brandenburg had not incited imminent lawless action, meaning that his rhetoric, while hateful, did not meet an immediate and likely threat of actual violence. In this case, the court maintained an individual's right to free speech and developed the Brandenburg test, which set a new standard for what can be deemed imminent lawless action. Tinker v. Des Moines. In the 1969 landmark case of Tinker v. the Des Moines Independent Community School District, a group of students were suspended from school for wearing black armbands as a protest against the ongoing war in Vietnam. The school district claimed that the students were violating school policy and causing substantial disruptions in class with their anti-war demonstration. The ACLU assisted the Tinker family with filing a lawsuit that went up before the Supreme Court. It was argued that the armbands were a form of protected expression, and the court found that the school district's suspension of the students was unconstitutional. This landmark ruling in favor of the students set the precedent for the Tinker test, where courts decide the constitutionality of punitive school policy to ensure the protection of students' free speech. Texas v. Johnson. In 1989, Gregory Lee Johnson burned an American flag in protest of the Ronald Reagan administration. He was charged with the desecration of a venerated object and convicted by Texas courts. Johnson argued that the state of Texas violated his First Amendment right to freedom of speech and appealed his conviction, claiming that his actions were symbolic speech. Upon hearing his case, the Supreme Court made a historic and controversial ruling in favor of Johnson. They deemed that his actions constituted expressive conduct, finding that burning the flag is indeed protected symbolic speech under the Constitution. Freedom of speech and the press are intended to protect expression, whether it be journalism and media, symbolic speech, or even the most unpopular of opinions.
Legislation and executive orders. The main legislation we found was the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. The main executive order that we found was Executive Order 13798. It was signed by President Donald Trump on May 4th, 2017. This executive order was basically an ultimatum to college campuses. It was saying college campuses should support free speech to receive federal funding. There was an issue at the time when this was signed, when a conservative activist was recruiting on college campus and he was punched in the face. This executive order was a bit controversial at the time, and then some people even seen it as hypocritical by President Trump just because of the comments that he was making about athletes at the time that were kneeling during the national anthem. Here we have our works cited page and where we got all of our information from. And this is going to conclude our presentation. Thank you all for watching to the end.